All right. Good morning, good evening, good afternoon, depending on when you are seeing this video. This is Prof TV, and today we'll continue with our law of contracts lessons. I didn't forget you people in 200 level, but I had just wanted to start something for my 100 level friends. Now, where we stopped, I know most of you have forgotten where we stopped. If you have been following me, you know I started with the meaning of contract. I started by introducing law of contract, and we talked about the elements that makes up a valid contract. And we have explained offer, we have explained acceptance, and we are on consideration. If you have not watched the videos that I introduced law of contract, the video that I defined or introduced what an offer is, and some other explanations that I preferred on offer. And if you have not also watched the video of acceptance, then I don't think this video is for you. But then, what I would just advise you to do is to pause and go back to the videos that I made to introduce law of contract, offer, acceptance, etc. Now, we are in consideration, and this is not the first video in consideration. This is the continuation of our lecture series on consideration. We've done the meaning of consideration and all that. So today we'll be looking at the meaning of executory and executed consideration. If you have watched my introduction to law of contract, there was a place I also explained the meaning of executory and executed consideration, which I told you that we would see it when we come to consideration, and this is where we are now. We'll look at past consideration. Past consideration. We'll now look at adequacy of consideration. Does consideration need to be adequate? We'll look at that. Then we'll look at sufficiency of consideration. When can you say that consideration is enough? When can you say that somebody has furnished a sufficient consideration? We'll look at that. And when we are looking at that, we are looking at what is something that is of value in the eyes of the law. When you say somebody has furnished a consideration that is enough, a sufficient consideration, something of value in the eyes of the law, what can that be said to be? Now, we will now also look at performance of existing duty. And under the performance of existing duty, we will now know whether performing something that you are already bound to perform, a duty you are already say, it is already imposed on you, whether it can form part of consideration or whether you can say that that is enough consideration. Now, we'll also look at duty imposed by law under the performance of existing duty, look at the duty imposed by law, look at the duty by contract with the promisor, that is the already existing duty you have in a contract when you are already in a contract. Then we'll look at a duty imposed by a third party, a contract with a third party. So you're already in a contract, but a third party has imposed a duty on you, whether that particular duty can be seen as sufficient consideration. So we start with executory and executed consideration. Now, if you have watched the other videos that I did, you would know that executory consideration is when promises are exchanged. Promise is exchanged for promise. When you say that something is executory, the consideration is executory. It means that when we are entering into a contract, no performance yet has been carried out. It is, I promise that I will do something for you, and in return, you promise that you will do something for me. That is executory consideration. So most of the times you might see in your test or your exams where they will set some things like this. Maybe A promised B that this is what he will do for you, and B also promised A that this is what I will do in return. What kind of consideration is that? You should know that that is the executory consideration. While the executed consideration, of course, is when promises are exchanged with performance. And we took examples of the reward cases where a particular person that is looking for his dog would say, please, oh, I am looking for my dog. And anybody that gets my dog to me, I will give the person 400 pounds. Now, giving the person 400 pounds, that is a promise. I will give the person 400 pounds if he gets my dog for me. Now, if you perform that particular thing, and you carry the dog and you come, you have performed your own side of the bargain, and that is your own consideration, and that other person's promise, is now enforceable because the person promised and you performed. That is executed consideration. Remember that consideration is something that would make you to have the local standing to sue when the other person has refused to carry out his own. For example, if I carry out my own consideration, for example, I bring back the dog for you, and I am not asking you, okay, give me my 400 pounds. And you're telling me that it is impossible that you cannot give me my 400 pounds. Because I have furnished my own consideration, because I have performed my own, I have the right, I have the local standee to sue you and to get my consideration back. So that is executory and executed consideration. Remember, I will take it again. Executory consideration is when promises are exchanged. No performance yet. I promise to do something, you promise to do something back. That is consideration, executory consideration. While executed consideration is when performance is exchanged for promises, or when promises are exchanged for performance. Now, when we now look at past consideration, we now see that past consideration is when a particular promise is made after the consideration has been furnished by the other party. What do I mean? Let us say, for example, I said, please help me take my bag downstairs. And I did not, before asking you to help me take my bag downstairs, I did not promise you anything. And when after you must have taken my bag downstairs, I now say, okay, because you've taken my bag downstairs, I will buy bicycle for you. Now, that particular I will buy bicycle for you is a past consideration. Why? Because the particular the particular thing that you're supposed to do in order for me to buy that bicycle for you to furnish my own consideration, you have done it before I promised to buy you the bicycle. So past consideration is not a valid consideration in law of contract. Past consideration is not a valid consideration in law of contract. Consideration should have preceded the contract. So if the consideration is done, or if the consideration is furnished after the contract must have taken place, after I must have done what I wanted to do, maybe gratuitously, and you now promised to do something for me, I cannot enforce that promise. Why? Because it is past consideration. The only time that I could enforce the promise is when that consideration has already been promised to me before I carry out that particular thing. So there is a case of Akenzua second of something. I think you look at that case in Sage, where the king was asked to help them, secure some lands or some reserves. Now, when the king did not ask for anything in return, no, the king just went there, was successful in it. Then, after being successful in it, he now told those people, see, this land that I have secured for you people, as the king, with my powers and with my influence, I would need 5 plots from there, for example. Actually, it's not 5 plots, but he would need some reserve, some own land, for some lands for his own use. Now, the other people agreed at first, but they said no, that we are not giving you. The king now sued to recover those lands. It was held that the king does not have any right of action. Why? Because he did not, before the contract, before going to secure those lands, he did not agree that the land or some part of the land would be accrued to him. So that was seen as a past consideration. That is why whenever you want to enter into a contract, you must settle on the consideration. You must say, okay, if I do this, what will I get in return? Because of course, consideration is quid pro quo, is the notion of quid pro quo, and that is what makes a contract binding. That is what makes a contract enforceable. So that is past consideration. Something you've already carried out a duty, you've already carried out your own side of the bargain before trying to even know what the other person will give you. Past consideration is not a valid consideration. Now, we will go into the adequacy of consideration. The question to be asked here is, does consideration needs to be adequate. Is it supposed to be that the adequacy of consideration should be paramount? When I mean, does consideration need to be adequate? If I say, okay, this iPhone 11, I am selling it for 2 naira, will the court say, no, that is not the price of that iPhone 11? The price of iPhone 11 is, what's the price of iPhone 11? Let's say 400,000. That the 400,000, anybody that does not buy an iPhone 11 for 400,000, in fact, it is he has not furnished the consideration. Adequacy of consideration. Is it like that in the law? The answer is no. Consideration need not to be adequate. It needs not to be adequate. It needs not, if I come out and say I'm selling my phone for 1 naira, as long as it is what I said I am selling it for, consideration is enough. You have furnished consideration when you paid 1 naira to me. So you cannot, because you paid 1 naira to me, and I will now say no, that ordinarily you have not furnished any consideration because 1 naira is not what the phone is. Yes, but you agreed that 1 naira should be paid to you. You cannot come around and say, no, 1 naira is not enough consideration, because consideration need not to be adequate. But then you should understand that exception to this that I just said is when it is under duress or fraud, or whether there is an element of fraud, duress, or undue influence. So maybe fraudulently, you might sell something to somebody, and that other person knows that this is not the price of this thing and now gives you, and because you are maybe ignorant of the price, you collect it. So when you come back and you prove your element of fraud, then they can set aside the contract because it is not enough. But apart from fraud, apart from misrepresentation, apart from duress and all that, consideration need not to be adequate, but sufficient. And that will take us into the sufficiency of consideration. Sufficiency of consideration is very simple. It is saying, especially when we now try to explain it in juxtaposition with something of value in the eyes of the law. As far as it is of value in the eyes of the law, then it is sufficient consideration. Now you might ask, what is it that is of value in the eyes of the law? There has been so many arguments on what is of value in the eyes of the law. Some people say, it should have economic value. It should have at least something to use to, when we talk about economic, there should be like a price tag on that. Even the case of Falogi and against Falogi, when they say that love and affection cannot be said to be consideration because it does not have any economic value. But then, long and short of everything is that in order for you to know the sufficiency of consideration, especially something that is of value in the eyes of the law, it should be such that, remember, we define consideration as the detriment, forbearance accruing from one party and benefits to the other party. As long as the consideration is something that is leaving the other party, or maybe something that would limit the other person to enforce a particular right. For example, it is enough consideration for me to not sue when I have the right to sue, maybe because you are owing me. And it is enough consideration for me to get the promise from you that you will add more money because you are not paying me now. So if you are owing me 10,000 and I say, today should have been the last day you would have paid me, but you say you don't have money, and I say, okay, no problem, I will not sue you to recover the money, but on the condition that you would pay me 15,000 when I extend the time for your payment in like 2 months. Now, if after 2 months you now bring 10,000 to me, and I said, no, we had agreed that you would pay me 15,000. You promised to pay me 15,000. And remember that consideration moves from the promisee. So it would not be asked, the question will not be asked, what consideration have I furnished for that promise to be enforced? Now, the mere fact that I did not sue you when you did not pay me my money and I extended the time for you is enough consideration. That's why I said that something that would limit you from exercising a right you ordinarily have. Because that is detriment to you and that is also benefit to the other person. Okay. Yes, that is one. Remember, we're looking at how do you know something that is of value in the eyes of the law and how do you know a sufficient consideration. So I said, if it is something that is leaving me, ordinarily I would have kept this. But because it is leaving me to you, probably, if I not probably, because you have demanded for it. So this marker can be a sufficient consideration if it is what you have demanded for. Now, it is immaterial if this marker is worthless. It is immaterial if the marker is not even working. So, if you say this marker, I want this marker for you to give me GLE 450, Mercedes-Benz AMG, and I give you this marker, and you find out that this marker does not have ink, you find out that it is worthless. As long as you have received this marker upon demand and it has left me, which ordinarily I would have kept, it is sufficient consideration for the Mercedes-Benz GLE 450 and 350. Now, that is something of value in the eyes of the law. Another one, like I was explaining before the call came, was when somebody forfeits exercising a right that ordinarily he has and can exercise. I gave you that example of somebody owing somebody and the person extends the grace to pay, but with a promise from the person that is owing that he will. So the consideration furnished for the promise of the other person that he will pay extra is that not suing you, because that's a right I have, but I said no problem because you said you pay me extra at a later date. It is enough consideration that I did not sue you to recover my money. So another one is, it does not, like I said, it must be something that the promisor accepts. It is something that was demanded and it has been accepted. So even though, like Sage would say, even though you demand 3 chocolate paper wraps, not the chocolate or the wrap, they are finished eating the chocolate, the wraps, it is enough consideration as far as you have demanded for them and they have been given to you. So you cannot turn around and say, no, it is worthless. No. Sufficiency of value in the eyes of the law is saying you demanded it, you accepted it as consideration, and it is enough consideration, it is sufficient consideration that has been furnished by the promisee. And when the consideration has been furnished like that, it gives the promisee the powers to enforce the promise that the promisor has given. Promise Akadia. Okay. Performance of existing duty. Now, if you do not understand most of the things that I'm saying, please do well to comment your questions. I will try as much as possible to see how I will communicate back the answers. Performance of existing duty. Now, the question asked here is whether a duty that already I have in mind to perform, not you have in mind, whether a duty that is ordinarily supposed to be performed by you, a duty that is imposed on you, whether it can form a part of a consideration. This is a duty that you know you must do. It is not as if you are trying to do it because you want to enter into a contract or maybe because you want something from somebody. This is a duty that has already been imposed on you. The question is, can it form a consideration? There are still arguments. While one party is saying that no, it cannot form a consideration because it is something that you are already going to do. So even though it is a detriment to you, it is something that you must have to do, not even because there is any contract there. That is what this party is saying. This school of thought is saying, no, it shouldn't be a consideration. While another school of thought is saying, it can be a consideration when the actual performance of that duty outweighs the remedy that the breach might bring. I'll give an example. If there is a duty on the builder to build a particular house within a time frame, maybe you want to build that house in your village before December, and you know that if you don't finish that house December, you cannot go to the village, and you want to go to the village on December because there is something very important, so one very great ceremony. Maybe they want to crown you the king of your village, or they want to crown you they want to give you one title, and you must have to be in your village, and you have paid the builder for the builder to build that house for you. Now, you would agree with me that the actual performance of the house outweighs any remedy. Now, imagine the builder does not build that house, and they'll say, okay, you have sued, yeah, so this is the remedy. You don't even want a remedy. No, not like you don't want a remedy, but you don't even want a situation where the builder will not even build the house. So in that particular situation, that already existing duty on the builder to build that house can be seen as a consideration for, a new promise. Maybe you might say, please, if you can, already you have paid him for building the house. Maybe you can say, if you can build this house before, if you can finish this house before November, I will give you additional 10%. If the builder finishes the house before December, by November, and you refuse to give the builder the additional 10%, saying that it was already his duty to build it, so why are you asking for more money, even though you have promised him? So yeah, you cannot say that he did not furnish any consideration by doing what he's supposed to do. So this school of thought is saying no, that he has furnished consideration by building the house to the finish, finishing it before that December. Why? Because the actual performance of that consideration outweighs the remedy where there is breach. So that is the two school of thought. One is saying no, it is not a consideration. How can you say that because this is something that you're supposed to do? So you cannot say it is a consideration. So whether this school of thought will win or this school of thought will win, let us look at it now based on some headings. We have duty imposed by law. Now, duty imposed by law is, these are the duties that laws have put on you. Yes. Okay, you can see from here, yeah, because I'm done with this. So, duties imposed by law. So, when you say duties imposed by law, you say the law has given you a duty. This duty is a legal duty. You must do it by law. If you don't do it, even you are even breaching the law. So, can you now say that duty imposed by law, if somebody has a duty imposed by law, it can be used to be a consideration for another thing? For example, can you say that a policeman mounting a roadblock is a consideration for a particular promise? Maybe you promise, you said, please, you know that the police people, they usually come out there, that particular roadblock, and you come out and you say, if you can stay till 6 p.m., I will give each of you a car. So that is a promise. So can you now say that them staying till 6 p.m. on that road is enough consideration, considering the fact that it was already a duty imposed on them by law? So the answer to that question is that it cannot be said to be consideration because they already have that duty imposed on them by law. However, of course, there are exceptions. When they now do extra, it is enough consideration. When they now do extra, so the law has imposed that they should stay there till 6 p.m. Yeah, for example, I'm giving an example. Now, if you now say, okay, why not stay till 12 a.m., like 12 midnight? Of course, I'm using this as an example, even though police are supposed to be staying from, I don't know why police will be closing when people are closing. Police are supposed to stay till the next day, like throughout the night. But let us just say the law imposed that they should stay till 6 p.m. But they now, you now ask them, please, there are some threats we are having. Please stay here till 12 midnight. If they do that extra duty above what the law imposed on them, then it is enough consideration. So you cannot now turn around and say, even though I promised you to stay till 12 midnight, it is your work now, it is what the law says. The court will tell you that no, the duty imposed by law is that they should stay till 6 p.m. They have done extra. So that extra is the consideration for your promise. Duty imposed by the contract with the promisor. So let us assume, just like the builder example I gave. You people are already in a contract. Yeah, you're already in a contract. And you say, please, this particular thing you want to do, if you do it, I will give you something. This thing that you are telling him that if he does, you will give him something, is something that ordinarily in the contract he would have done. Just like the builder. Okay, I'll give you another example. Supply me 20 bags of cement. The person knows that he will supply 20 bags of cement. Yeah? Then I now even put a call across and say, please, supply that 20. If you supply that 20 bags of cement, I will give you one plot of land in addition to the money I say I will give you. If the person comes with that 20 bags of cement and now starts asking for the promise you just made, yeah, the law is this. Just like the duty imposed by law, you have not furnished any consideration because that particular duty is a duty that ordinarily you would have done. Yeah, so, but then, like the duty imposed by law, if you now go ahead to do extra, then it is enough consideration. Bring me 20 bags of cement. And if you bring me 20 bags of cement and you help in mixing it with the sand, I will give you one plot of land. The existing contract says bring 20 bags of cement. Now, putting an extra promise, means that if I do that extra, I have furnished consideration for your promise. So that is it. By contract with the promisor, it's just almost the same with imposed by law. So you should know that the two of them are. Now, duty imposed by contract with third party. By contract with third party. Very important. Now, listen and listen attentively. If I am in a contract with you, it's you, me and you that entered contract, you that you are watching me. Now, another person would benefit from that contract that the two of us entered. And that person makes a promise and says, if you sorry, I'll be fast. My lights just went off. Just listen. You don't need to see my face. Just listen. So that person now says, if you do this thing that you have entered into a contract with this person that is saying this, making this promise, is not with us in the contract. Though. It's just two of us that entered into a contract. The other person now says, please, if you do it, I will benefit from it. If you do it, I will give you additional money. Now, if I do that, that person that promised that he will give me additional money cannot come around and say, you were already supposed to do this thing now. Because it is a contract imposed by it is a duty imposed with contract by a third party. I'll give you an example. That's same 20 bags of cement. I am the dealer. You are the transport company. I said, supply 20 bags of cement to Ada. It is two of us that entered into contract, but Ada will benefit. Now, Ada now called you as the transport company and say, please, if you supply these 20 bags of cement, I will give you 5 million naira extra to what the dealer will give you. Ada is a third party, and that is a duty imposed on you by a contract. So the law is not saying that particular duty to supply, that's one that Ada is saying, the third party. If you now supply, she has to give you that 5 million because it is enough consideration. So unlike the duty imposed by law and the duty imposed by contract with the promisor, the one imposed by contract with third party is enough consideration. So when next we meet, we will talk about variation of contractual rights. Then we will now finish consideration. I will now enter into intention to create legal relations. Please, sorry for my lights that went off. I did not charge it well. Good night. Take care.